While we're assembling, I want to tell you a story. 2010, I was contacted by a law firm in Chicago that I deal with sometimes. They wanted to do a program for clients, potential clients, other lawyers. Would I come out and speak? Sure. They had Michael McGrath, who was here this morning, then Insurance Commissioner of Illinois, as the keynote speaker, but they needed somebody else to fill out the program. Asked me, I said, get Dan Schwarcz, who is the best young insurance scholar in America. So I'm 7 or 8 years ahead of the ALI, apparently. As Ricky and Stephanie pointed out this morning, this event coincides with the impending completion of the Restatement of Law of Liability Insurance project, which has generated both light and heat. For light, a word from my sponsor at least, look at 68 Rutgers University Law Review for a symposium on the restatement, which coincidentally was at the moment it transitioned from a principles to a restatement project. For heat, you can look at some of the business news reporting and so forth. But however that process works out, the question is, what, if anything, is next? And our panel today will talk about some of the choices made in defining the scope of the Restatement of Law of Liability Insurance, whether we should go forward in some direction, and if so, what, and how that fits within the ALI process. Let me just briefly introduce the speakers in the order in which they will speak, though you either know them or know who they are. Ken Abraham of the University of Virginia, who created a lot of the field in which we work. Kyle Logue of the University of Michigan, who in addition to his scholarship is associate reporter of the Restatement of Liability Insurance. Lorelie Masters, who is with the firm now named Hunton Andrews Kurth as of this week, formerly Hunton Williams, a leading policyholder side coverage lawyer, and Bob Cusumano, recently general counsel of one of the global property casualty insurers, ACE. So starting with Ken Abraham.
So thank you, Jay. Thank you to everybody. I want to add my compliments to the American Law Institute for sponsoring this conference, and my congratulations to Dan for doing work of a quality that warranted the early Scholars Medal. So kudos to both of you. I do want to say, since most of the people here are insurance people and not, here generally because of your involvement in the American Law Institute, that there's been an initiative in the last 8 or 10 years begun under Lance Liebman, the former director, and now carried forward by Ricky Revesz, to try to energize young legal scholars' interest in the work of the American Law Institute. The Early Scholars Medal is part of it. The conferences like this are part of it, and so I'm really glad that it's happening. I want to talk about two subjects very, very briefly. First, the institutional considerations that are likely to influence whether and when a first-party insurance restatement is undertaken, and secondly, some methodological considerations for which our experience with the Restatement of Liability Insurance, RLLI, may provide some lessons. So first, institutional considerations, and I'll give a disclaimer, which is I was on the Counsel of the American Law Institute, the governing board, for 21 years. I'm an emeritus member of the Council now, but in any event, I don't speak for the Council, and I'm not going to say anything that I ever heard anybody in management or on the Council say. I'm making predictions and drawing inferences. I'm not letting out any secrets. To oversimplify, what I'd say is, politically speaking, there are two categories of projects that the American Law Institute carries on, whether they're restatements or principles projects or some other format. In one category are those in which lawyers' practices don't automatically align with one interest or one side in a bilateral situation. So donative transfers, wills and trusts, property law, children in the law, those are examples in which a lawyer may in one setting represent a testator and another setting represent a beneficiary. So there aren't lawyers who are sort of testator lawyers and lawyers who are beneficiary lawyers. And the same thing with lots of other fields. In contrast, some projects actually are divided into lawyers who practice for one side and only one side, or another side and only the other side. Employment law divides up that way. There are labor lawyers and management lawyers. Criminal law divides up that way. There are prosecutors and defense lawyers. Software contract law divides up that way. There are sellers of software, and there's all the rest of us. And there are lawyers for the sellers of software. And RLLI divided up that way mostly into policy lawyers and insurance company lawyers. Of course, there were professors and there were judges, but the lawyers involved represented almost exclusively one side or the other. These latter kinds of projects tend to be more contentious than the former kinds of projects. Now, the American Law Institute cannot and should not, and I'm sure will not, shy away from the second kind of project merely because it is likely to be contentious. But contentiousness leads to a project taking more time, management having to field and respond to complaints by interest groups, deal with adverse publicity, op-eds that attack the very ethics of the American Law Institute for, taking a position about the duty to defend. And it's only natural to expect that only a portion of the ALI work product can be occupied by projects that fall into this second category. There's only a limited amount of time and institutional resources and credibility and goodwill to devote to contentious projects. So the experience with the RLLI, which I would say has been at about the 80th percentile in terms of contentiousness, and here 100 percentile is the top. You can get to 100%. That experience is likely to lead the powers that be. This is where I'm just making a prediction and drawing an inference. I never heard anybody, I've never heard a single person with power say this to me. I just think that that's likely to lead the powers that be to be cautious about undertaking a first-party insurance restatement anytime soon, even though it might not be quite as contentious as RLLI was. A first-party insurance project is probably going to be listed on the agenda of possibilities, but it may not get a high priority, especially since there's already a waiting list for lots of other worthy projects. It doesn't mean that scholars shouldn't do the intellectual preparation for that. I think they should. This is the beginning of that. What we did here today paves the way. In other projects, prior to the products liability restatement, Henderson and Tversky, who became the reporters, did some work, law review work, about what a products liability restatement could look like. Several other scholars did that about intentional torts, which is now a project. So that's the way you prepare the ground for this, is some intellectual work is done before the ALI decides to take it up. And that will have to come first. So the second subject I want to talk about briefly is methodological considerations to take into account as we begin to think about what a first-party insurance restatement might look like. Well, we learned in the RLLI that level of generality and level of particularity is crucial and it's difficult. There are thousands of rules of insurance law in particular contexts. Look at the dozens of volumes of the Couch and Appleman treatises. There's a one-volume treatise on torts. There's a 26-volume treatise on insurance law. You cannot and you should not restate all of that. So really what we were doing in the restatement of the law of liability insurance was doing a restatement of the principles of the law of liability insurance. It doesn't say that, but that's what it is. And the same would have to be the case for a first-party insurance law restatement. And the question is, how do you do that? Some general principles are obvious. I think some of my colleagues will even talk about them. Insurable interest, right? That's a general principle. You can restate that. But some general principles are actually applicable only to certain forms of insurance. The rules governing assignment of a life insurance policy are about assigning a life insurance policy. What counts as physical damage for purposes of property insurance is another example. It's about property insurance. I think those should be included in a first-party restatement. I don't think they're too particular, but what criterion is helping me decide that? I'm not sure. So how to conceive of a restatement and a set of provisions dealing with principles and particular types of first-party insurance is going to be a challenge. And of course, there's separately going to be the question of how to handle health insurance, which has to be included in a first-party insurance restatement, but is now so heavily regulated statutorily and administratively that the traditional approach to restating the law will have to be adjusted somehow for this field, and it isn't clear exactly how. So my message is, I'm glad we're talking about this. It's important to talk about a restatement. The ALI, I'm sure, would not want to have a restatement of liability insurance law and leave out the other half of insurance law. But we can't just turn around and move to it. It's going to require some thinking, some conceptualizing, some vetting. I hope the ALI eventually does it, and I think it'll be good eventually to do it, but we have to do a lot more thinking about it before a first-party project can be a reality.
Up next. So, a while back, I'm Kyle. I'm one of the, I'm the associate reporter of the restatement of the law of liability insurance. And shortly after a meeting a while back, Dan came up to me and said, "What about this idea of a first-party insurance restatement?" And I laughed and said, "You're kidding, right?" And he said, "No, think about it seriously. Think about it." And so I thought, you know, I'll give it some serious thought. So what I want to do today, I'm going to keep my remarks brief as well. But what I want to do is talk a little bit about some things that I think a person might want to think about if they're imagining being a potential reporter on a restatement of the first-party insurance law. So I'm gonna revisit some big conceptual questions that Tom and I faced together with the help of some advisors at the very beginning of the restatement of the law of liability insurance. Then I'll do a quick and dirty review of what I think are some rules in the restatement of the law of liability insurance that seem to apply to first-party insurance in a sort of obvious way and therefore might not need to be restated again. And then third, I'll talk a little bit about a few insurance-specific types of issues that we did not address that would be obvious candidates for treatment under new restatement, some of which overlap with what Ken said. And then I'll conclude very briefly with a comment or just a question about this genre of restatement that a future reporter might want to think about. So the big conceptual question we first faced was sort of how to organize the field of insurance law. What is insurance law? That's not a question people ask themselves very often unless you're writing a treatise or a casebook or something, or maybe trying to explain to your students why to take your class. But and it's a lot of things, right? There's regulatory aspects of it, but the parts of insurance law that are well fitted for restatement are basically contract law rules. And some might even say that insurance law is really just contract law. It's just an straightforward application of contract principles to standard form in insurance contracts. But anybody who's read any insurance contracts at all knows that that's not true. In insurance context, those tools of contract interpretation and et cetera have their own valence. In addition, because standard form insurance contracts themselves have their own peculiar terms, as courts apply the doctrines of interpretation and the tools of interpretation to particular insurance contract terms, a kind of common law arises about those terms that you don't see in other areas. Just for one example, Ken mentioned the duty to defend. The duties to defend, the duty to settle, these arise out of courts' efforts to try to interpret and give meaning to and make sense of provisions in insurance contracts that give insurance companies the rights and obligation to defend and the discretion to settle cases. But it's a kind of independent jurisprudence that very much deserves restatement, in my own biased view, and we have tried to do that. I should say that knowing that insurance law is a coherent, and so my conclusion would be that insurance law is a distinct field. That's sort of the first test you have. The next question is how to organize it. So that was hard. Ken has alluded to how hard it is to sort of figure out what to put in and what to leave out. And Tom and I thought about it. We asked for advice. We tried crowdsourcing it with our advisors. They didn't really have a lot of advice on this particular question. They had lots of useful advice from which I learned a great deal about particular sections. But this overall how to organize thing was really hard. So we did what we did. You know, we have a chapter 1 on insurance policy, on contract doctrines, you know, interpretation, misrepresentation, waiver, estoppel. Chapter 2 is where we address defense duties, duty to settle, duty to cooperate. Chapter 3 is a section where we deal with a lot of doctrines that have arisen out of courts' effort to interpret particular provisions in insurance contracts, liability insurance contracts. And Chapter 4 has rules governing implied law terms, remedies, and bad faith. And so that's the structure we came up with. It's a way of organizing things. One thing I'll point out in terms of a cautionary note is there's an additional risk to attempting a restatement of insurance-specific rules that are, by necessity, based to a large extent on the specific language of particular insurance policies. There's the problem Ken mentioned, the problem of picking the right level of generality. The rule must be sufficiently general that it will apply to a class of contracts that are in wide use, but it cannot be so general that it is unclear how the rule would apply to particular policies in particular situations. That's not so easy to do. And then there's the where do you stop problem that Ken mentioned. If there are 1,000 rules, how many do you include? I don't think that's as big a problem as Ken thinks. I wouldn't call it the restatement of the principles of the law of liability insurance. I might say it's the restatement of some of the laws of liability insurance. And we didn't get a lot of complaints about that. We didn't get people saying, you know, here are a list of the rules from Couch that you didn't restate. Get on those. Instead, we tended to get the opposite. Could you not restate that rule that you restated? Just drop that one out. But anyway, it's an issue. The bigger issue that worried me, and that actually Ken put me onto early on, which is because most of the insurance law rules that we're restating are default rules that can be altered by changes in the language of the policy, they have a risk of obsolescence. If the insurance industry changes the wording, the rule disappears. One can plan against this kind of obsolescence by trying to state rules that rely on contract terms that have been around for a long time or that are in wide use, because then if insurers are going to change the language there, it seems unlikely they might do it because they also lose the benefit of all the contract law that you're relying on to state the rule, and that creates uncertainty for them. But the possibility of obsolescence in this area is a problem. So which rules set forth in the restatement of the law of liability insurance could cross over and apply to first-party insurance context? I think it's pretty obvious. Chapter 1, pretty much all of it is the rules of contract law. I won't go through them all again. Chapter 2, probably not. Probably none of Chapter 2 and the duties to settle and duty to defend and all of that. I think that probably doesn't apply. Some of Chapter 3, I mean, concepts such as trigger and allocation and the number of occurrences are terms that arise in property policies. Maybe some of what we did here could translate. And also some of Chapter 4. Certainly the definition of bad faith. We saw as many first-party cases as we saw third-party cases when we were doing our reading for this. So a fair amount would carry over. What's left to be done then? Ken mentioned insurable interest. That would be a very interesting thing to explore. I would also mention the problem of concurrent causation. You know, when you have an excluded cause and an unexcluded cause, what do you do? Do you use the efficient proximate cause doctrine or not? There are interesting issues there. And subrogation. We mentioned subrogation in one section, but largely leave it untouched. So I would think subrogation would be a rich area to explore. So I think there's stuff to work on. I defer to Ken on whether it's plausible that it could be done now or when it might be done, but I think there's enough there to do another restatement, a much shorter one. It won't take whatever ours, 25 years, whatever ours took. It'll take less than that. And then one quick final thought on the genre of a restatement, because that's what you'd be working in, I think. I think once one of them's a restatement, the other one has to be called a restatement. I don't see how you'd go to principles on the next one. According to the ALI style book, restatements are to be clarifications or reformulations of existing law, and to that end, they tell the reporters to look at a number of factors. What is the majority rule? Like what do most courts do? What are the trends among the courts? What rule provides the greatest coherence? And then which rule is most desirable? And these are the things you're supposed to consider. So I have some quick thoughts on these things. I would say there's also an unstated limitation that's not in the rules that we felt anyway. there is a strong preference for verbal formulations of rules that judges and lawyers are familiar with, even if they are not clear. I don't know how else to say it. It's just true. And we bumped up against that a number of times and had to make adjustments because of it. In choosing between alternative, this is the second point, I'm closing in here. In choosing with the alternative rules on the grounds of relative desirability, it presents a very familiar and difficult question, especially for law professors. What is considered a valid or persuasive reason for concluding that one legal rule is more desirable than another? The ALI style book offers some ideas. They say you can look at social science evidence or empirical analyses. They don't say that's exclusive, but they offer those as possibilities. But you really are confronted with a question of what counts as an argument for what's a desirable choice of a rule, and how is a restatement author supposed to deal with that? And I'll conclude with a hypothetical. Imagine that there was a jurisdiction out there that adopted, I don't know if I should call it Omri's rule or Steve Morrison's rule for interpreting the plain meaning of insurance contracts. Let's say, I'm not saying any states has done it yet, but let's say the Supreme Court of some state adopted that rule and said, this is what you should take into account deciding plain meaning, these surveys and this database. Let's say maybe 2 courts did it. 2 high courts have done it, but only 2 high courts. And let's say you think it might be an interesting rule to adopt. On what basis would you adopt it? Like, how would you decide that this is a rule that we could adopt? It'd have to be on relative desirability because it's not a majority rule. What are the criteria for deciding desirability? Do you have to show that the adoption of such a rule does not radically increase premiums or reduce coverage? Appears not to have in that jurisdiction, but we don't have a lot of evidence on whether it does in other jurisdictions. These are difficult questions for a reporter to answer, and thankfully, they're almost no longer my problem.
Good afternoon. Lori Masters of Hunton, Andrews, Kurth. The first time I've said that in a gathering of this size. I come to this as a practitioner. I've always practiced law since I graduated from law school. And for most of that time, with the exception of a brief interlude at the very beginning of my career, I have been in the insurance coverage field, and I've represented policyholders. I think those of you in the audience who know me well certainly, or even just know me, know that that's my perspective. So I come at this from a more practical perspective. It's always awesome as a practicing lawyer to be in a room of really big thinkers, and that's what this group certainly is. And it's been a real privilege to be a part of the restatement as an advisor, and it certainly has been a learning experience because I think one could fruitfully give a semester-long course on how one should engage in a restatement and how the ALI process works. So it's a complicated process, and I say that only because it's the process is there for a reason, and I think that it seeks to reach the very best result. So with that, in terms of the current restatement and whether a property or first-party insurance restatement makes sense, I have a few perspectives. I think it needs to be said that the structure of the groups, the advisors, and the members' consultative group, or maybe it's specifically the advisors, needs to be very well thought out. And of course, I think that was done here, but I also think that we would bring, the royal we, would bring the experience from the liability insurance restatement to a decision of who would serve as advisors to a first-party restatement. So we policyholders think that there could have been more of an affirmative representation by the policyholder community on the restatement. There is a liaison from the American Insurance Association, and there's not a similar liaison from the policyholder side. Now, it's easier because of the institutional organization of the insurance industry to bring the liaison from the insurance industry, but I think that these projects and life in general, projects in general, benefit from the perception and the reality that all sides are equally represented. So I would put that out there, perhaps grinding my axe, but I do think that it ultimately leads to the best possible product. I was interested in your comment about contract law versus insurance law, and as a practitioner and having participated in this project and also seeing the recent revisions to sections 3 and 4, which deal with interpretation, plain meaning, and ambiguity, I think there is a real conviction on my part, at least, that insurance law in this context is not exactly contract law. And I think that that might be something to consider in deciding or thinking about a first-party insurance restatement. I think there are a lot of provisions that in the transitioning to the question of what translates and what doesn't. There are a lot of provisions in the liability restatement that I think transfer, but they don't transfer as easily, at least to me, as I think it sounds in a general conversation. Because when you actually go and look at a lot of these provisions, there's a lot of discussion of liability insurance, legal action, and of course examples and discussion of concepts that really relate to liability insurance and don't really relate to first-party insurance. So I think you could maybe use a lot of the black letter, for example, but you would really have to go back and think seriously about the comments and the reporter's notes. Now, I understand that reporter's notes are just that. They're reporter's notes. They don't have the binding authority as the position of the ALI. But they provide important context, and a lot of that, I think, would have to be revised. And the commentary certainly would have to be revised as well. Some examples of that, I think, to get to what Kyle was saying, waiver and estoppel, for example, the interpretation principles, those specifically, I think, would have to be looked at carefully. I think trigger and allocation, those might have to just start from ground zero, or at least start from 30%, perhaps, to use a good percentage that's been here today, because trigger is different in first party. At least certainly the way I think about it as a practicing lawyer and looking at the language, which is direct physical injury, in most of the policies that I see. And allocation, while that concept exists in first-party cases, is not the same at all, at least in my view, as it has been litigated or it really gets applied in the liability context. So, of course, I have done a lot of really big liability cases, as my colleague here, Bob Cusumano, has, and both his life as a practicing lawyer, and I had the privilege, or maybe the the unfortunate experience of opposing Bob in cases, and then also, of course, when he was in-house counsel, general counsel, I should say, for ACE. So I think that a lot of these concepts would have to be looked at pretty carefully. I would say in terms of concepts that I don't see in the restatement of liability insurance that should be considered, I agree the insurable interest is an important one. I already talked about direct physical loss or physical injury, and someone else here on the panel today mentioned that. I think causation, again, is an important context or issue to consider. I would think about things like, in general terms, appraisal and proof of loss type issues, because those really, in the property insurance context, often are really the game. There may be disputes, even if there are no disputes over the actual application of the policy language, the valuation issues can tie up a claim for a good period of time. And in more recent cases, coming out of a lot of the recent disasters, this issue of how appraisal is applied is an interesting one, and I think gets misused because it really should be a valuation method and not a method of resolving coverage issues. And I think that concept would bear addressing in a first-party restatement. I think an interesting thing to think about from my perspective as a practicing lawyer also is that the idea about having a restatement of liability insurance, a restatement of property insurance, ultimately, would one not consider having a restatement of insurance in one volume? Now, the problem or issue that I have there in thinking about it is that there are certain concepts in insurance disputes, insurance litigation, that in my view are really first-party concepts, and they've bled over into the third-party liability insurance context. And having one restatement would actually perhaps exacerbate that tendency. Now, is that a good thing or a bad thing? I don't know. I think we all may have opinions about that, but an example would be from the environmental insurance coverage wars, which have been vigorously fought during my career. Known loss, known risk. I really thought of that, at least back in the day, as a first-party concept, but it got brought in to liability insurance, and of course is an issue that we as practicing lawyers for policyholders have had to deal with over the years. Another recent example is from the Washington Supreme Court in the Zia case, where they brought in efficient proximate cause into liability insurance. And I think insurance company lawyers would agree that that has created a lot of consternation, and with the attendant concern about how does that really apply, or how does it affect the application of the exclusions in a policy. So the thought in that case was that you would not exclude a claim for carbon monoxide poisoning as pollution unless that was the pollution, the carbon monoxide, was the efficient proximate cause of the injury. And the court said it was not. It was really the installation of the defective equipment that led to the release of carbon monoxide. So it said the pollution exclusion did not apply. Does that make sense in the liability context? That's a question. So those are the kinds of things that I thought about when I was asked to be on the panel here, and I'm looking forward to what you, Mr. Cusumano, have to say.
I agree with all that. I want to say a few things about the restatement substantively as far as what to expect in the future, at least as my crystal ball might predict that future. But let me start by echoing and maybe extending a few of the comments of my fellow panelists about the process. You know, I've said to people I work with for many years, especially my staff at ACE, that law gets made in many ways. And I think the general public thinks that laws are passed or judges issue decisions, and that's all there is to the world. And we all know that it's quite a bit more complicated than that. And the result is this magnificent intellectual infrastructure around the law in this country that allows organizations like the American Law Institute to tap into the academy, to tap into the private sector, to tap into the law firm industry on either side or on no side of an issue, and to issue what is in effect a report in the form of a model law about an area of the law that has been developing unbelievable complexity over hundreds of years. And when I look at that process in terms of participation in law creation, I think this process could not have gone better over these last 6 years, which is not that long. I also want to just make a sharp distinction while agreeing with Ken and everybody who saw how controversial some of the parts of this process were, as they should be. We were dealing with tough stuff. But that controversy was handled one way in the room and another way outside the room. And I know I speak for most or all of the advisory committee members in thanking the ALI and the staff for insulating us from the external pressures being brought to bear on them to allow us to have the most unbelievably productive conversation over an extended period of time that I've ever had in my 40 years of being part of this profession. I think that parts of the conversation we had were legitimately describable as beautiful or brilliant. Parts of it involved old adversaries having the most constructive conversation they've ever had in their lives with each other. And all of it was done under the auspices and supervision of a couple of young men who could not have been more patient and thoughtful or better leaders. And we needed that, and we got that. The result of all that is a product that I think all of us are proud to have our names on in whatever section we participated. I think Tom and Kyle ought to be immensely proud of what they've accomplished. I would challenge anybody at any insurance company, any policyholder law firm, to find a paragraph in there that isn't a reasonably stated point of view, maybe subject to disagreement, maybe you do disagree with it. But for a document that's running like 500 or 600 pages, it is a magnificent work of just sheer competence. So with that, where do we go from here? And I wanted to just share two thoughts with you about, one is about the restatement itself and an issue of particular concern to me over the years that's been addressed here. And then the second is about a future restatement on the first party side. Within our document as it stands now, as everybody knows, it is a distillation of what we thought collectively after debate would be the best way to express insurance law. And that means expressing some very difficult interconnections among individual propositions of law. And what I liked best about this process is those interconnections got explored. And we understood that we were dealing with, what as a child I used to call the game of 52-card pickup, where courts are doing individual issues all over the place, coming to a reasonable conclusion on what they have in front of them, but nobody's building it systematically so that the product, that is the insurance policy, is going to work for people, the people who issue it and the people who buy it. And that was, for me, the overarching objective of this process and the reason why I was so supportive of the idea of trying to do this. And I think we accomplished that. But one of the places where we accomplish that involves, 4 or 6, depending on how you count, 8 different significant provisions within the restatement as it's currently drafted. And all of those revolve around the general subject of claim handling. They concern the duty to defend. They concern the duty of good faith and fair dealing. They have a lot to say about whether to settle, whether you have to settle, on what basis can you refuse to settle. They have much to say that's old and new about what the sanction will be if you violate any of the foregoing obligations. And so this array, which I considered to be one subject with 20 or 40 subparts, was finally put together. It was really, really hard. It took 2 years, I think, just on this, and we went back and forth several times. The result of this is an array that largely reflects what I think of as the majority rule and the fairly strict enforcement of the duty of good faith and fair dealing in the context of insurance contracts, and enforcement of those duties in ways that normal everyday contract law perhaps has sort of forgotten about and they don't do anymore. I think that's the right thing to do because insurance is such an executory thing when you buy it. You're buying a financial package, an obligation to pay if something happens. You're buying the right to be defended in court, which is a very different thing. And I think you're also buying, and I would hope that the insurance industry would agree with this, an interaction over time as those duties are fulfilled with a counterparty that's on your side. So there's a little bit of a paradox and almost a self-conflict of interest or a selflessness that we have to enforce in these provisions. And the array that was put together, while I think it mostly reflects majority rule, is a bit more punitive for not following those rules and duties, and I think that's right, and that's the way it ought to be. On the other hand, you could say that it's a minority rule or not even a rule at all because I don't think anyone has ever really tried to put it all together in one place in the kind of cookbook or rule book that's been created under the guidance of Tom and Kyle. So my prediction, given the fact that there are, a couple of million liability claims in America every year, and just in America, is that the triangular relationship, policyholder, insurer, plaintiff, is going to be disturbed to some degree by this new integrated array of rights and responsibilities. And remember that each point on that triangle has interests that are in common with another point, but opposed to each other point as well. And so creating that mix isn't that easy, and seeing it work in the field is going to be very interesting, because you have policyholders who want to get out of a liability claim, and so you'd think that they want to have somebody pay it. But sometimes they don't want to have anybody pay because they don't agree they did anything wrong. And they surely don't want to have somebody pay too much so that it affects their insurance rates in the future. The insurer often wants to get rid of a claim, but more often wants to suppress the value of it or the price of it. That creates a tension with the policyholder. The plaintiff almost uniformly wants to increase the amount to be paid by somebody, and they don't care which one of you pays, right? And so this roadmap that's been created through the assembly of general principles about how to behave yourself is going to guide two of those three parties, and not the third, not the plaintiff, right? But they're going to see the effect of whether this guide works in the field. I found in my experience, in the industry and before that, litigating on behalf of the industry, and sometimes against the industry, by the way, that the world delivers you richness and complexity that you can never anticipate. And into this machine that's been built by the ALI will be delivered, thousands of new tough cases that are going to stretch the edges of what has been done here. And I think in particular, with regard to claim handling, is going to lead to more conferences like this one in the future to see if we're getting it right or whether it needs to be tweaked. I'm going to close with just the notion of a restatement of first-party insurance. And I was saying last night, it feels a little bit like when you're hungover, somebody saying, let's have a party tonight. So I can't be totally objective about this, but I don't think it's going to happen, and not for political reasons. I think that first-party insurance is not as densely complicated in a matrix kind of way as liability insurance is. But I also think, conversely, that there are issues about what insurance should pay for in the first-party context, in particular the health insurance context, that are so existential and metaphysical, pick your funny word for it, that there's no point in going near it. For example, let's just go back to Sarah Palin's death panels when she forgot that health insurance has had death panels and always will, because they're either public or they're private, but somebody's deciding what treatment we're going to pay for. And if the ALI wants to tackle that one, they're going to get into religious circles that I think are not, it's going to be very, very difficult. And if you don't tackle that, then where do you draw the line about what you're going to say about what's going to be covered? Because you've excluded then the absolute hardest issues. And it's not just about end-of-care health coverage, end-of-life health coverage, or the question of how much investment is too much in health care. Those same things happen to sort of percolate throughout the first-party property world. And I think those distinctions will be very difficult to draw. And if you're not going to do that, I'm not sure you're adding much to the whole mix. So I'm going to stop there, and if you'll just permit me 15 seconds, Tom is not here, but Kyle is, and I want to thank you for allowing me to learn and to be a part of your process. Thanks.
We have time for questions. We have time for questions. The first question is always hard if someone would like to ask a second question.
Well, so I guess I'll ask a question then. So some of these concepts that are in the current liability insurance restatement project, it seems to me it's probably appropriate to think about if you were going to be turning them to the first party, you sort of want to take 30%, right? So I think a really good example is the trigger and allocation, which sort of has some similar principles, but you'd probably also want to. So how would you go about actually doing that as a practical matter? Would you sort of just say, the trigger and allocation rules in the liability insurance section are just for liability, and for first-party insurance, here are the rules? Or would you say, these rules that apply there also apply here, but here are additional rules? Or would you say, everything in the liability insurance, some of what's in the liability insurance section, they're not written as liability insurance rules. And so would you actually say, sort of essentially create some sort of meta rule, everything in the liability insurance restatement is applicable to liability insurance and first-party insurance unless stated otherwise? How would you nest together a first-party insurance and third-party insurance restatement to create a restatement of liability insurance? Is it even possible?
Wow. So that would be the question you would spend the first 2 weeks agonizing over. So I think it would be some of both. I mean, it might. I mean, what you would probably do is start restating it all from scratch, and imagining that you might use using the restatement of liability insurance as a reference. You go back to it and say, as you go through the first party insurance drafting, has this completely been covered already? And if it hasn't, you restate it yourself. But there may be whole sections of it that can just completely translate. Although, as Lorelie points out, the reporter's notes, to the extent we cite exclusively liability insurance cases, you're going to have to completely rewrite the reporter's notes. To the extent the comments speak about liability insurance, you're going to have to revise. You're going to have to revise those. I think you're going to have to take it on a case-by-case basis and start working through it. I mean, this is the hardest question. This is like the hardest question. I guess what I would take Ken's suggestion, and assuming this might be a while before the ALI turned to this particular thing, I would pick a few issues that you think might be the core issues that you would address. And if you haven't already written an article about it, begin doing research to write an article about it. Like, begin to think about what you would say about a particular topic in the case law in that area to begin to lay the groundwork for it. Because you'd be in a better position. You'd produce some useful scholarship along the way. You'd be in a better position if they ultimately decide to do something like this. That's how I would spend my time. The thing that you're describing now is the hardest, least pleasant, least fun part of the job. And there's a lot of fun parts. Learning from the advisors, including everybody on this panel, about insurance, the practice of insurance law, is one of the great career moves I've ever made. I thank the people that asked me to do it. And working with Tom, learning from Tom. So there are all sorts of reasons to want to do it, to want it to work, to want the ALI to decide to want it. Just speaking personally, I would put off that particular struggle to figure that out a little while until they seem further along, and I would spend time on particular questions that you think you wanted to write about anyway.
Can I ask you a question that I'd like to start with Kyle, but then see what others have thought. There are a couple of points, a couple of sections in the current restatement where the discussion in the comments and the reporter's note points out that much of this law is statutory, or in some of the states it's statutory. And I can imagine as we move into property insurance, life insurance, other sorts of things, let alone health insurance, this becomes much more problematic. You talked about how we come to a valid rule.
Right.
Could you respond to that a little bit?
So, I've used restatements when I teach. I've been teaching torts for many, many years, and so I'm familiar with restatements. But I hadn't fully thought through the process, as anybody would, until you're in the middle of helping draft one. And so I guess it hadn't occurred to me fully how much restatement rules are supposed to arise out of the common law, and not from a statute, until I'd gotten into it. And this is something we learned, for example, with respect to misrepresentation. Back when it was a principles project, and we had much more freedom to do, innovations, to engage in innovative rule writing. We spent a lot of time on misrepresentation, and we had, for example, borrowed from many statutes this idea that there's a kind of exception for innocent misrepresentation, or misrepresentations that were unintentional and neither, also not reckless. And I had a lot of, I liked that rule a lot. I think it would respond to Rick Swedloff's Pete problem if we had a rule like that. But we then found out that there were no jurisdictions that adopted this rule, as a matter of common law. And so I think this is a difficult question. I'm not sure that this is the only way to do a restatement. One could imagine restating, could have the choice of rules in a restatement being at least conceivably arising out of what was originally legislation, right? That could happen. And we didn't push the envelope a lot on that. A person could push it harder.
So, could I comment? I think that, Jay, the question poses a difficulty, but it's one that the Institute has to come to terms with and is in the process of doing it. Restatements can't only be about fields that are 90% common law. The world is more complicated than that now. Common law fields are chock full of statutory modifications. If they're going to continue to be restatements, there has to be a way of restating that takes account of a field being penetrated to some extent by statutes. The paradigm now is that restatements are addressed primarily to courts. It doesn't mean they can't be partly addressed to legislatures. So I think that, that can be accommodated. And there are statutes and there are statutes. There's some kind of statutes that have a pattern, right, without you having to worry about the particulars. There are, in every state, there are, in health insurance, there are mandated benefit laws that require different sorts of coverage. Now, it varies from state to state, but those are statutory. I haven't studied them very carefully, but I'm sure there are, there is law about a number of issues associated with the reach and scope and applicability of mandated benefits laws. And so that would be the sort of thing that a restatement would address, even though it's statutory. You can't resolve these questions in the abstract, but I'm pretty optimistic that the fact that some common law fields are partly penetrated by statute, including first-party insurance, is something that can be dealt with, and that you're going to get a lot of support from very smart people on the council and advisors who will help you figure out not only substantively what to do, but methodologically what to do, because they've had so much experience with it.
If I could just add one thought, I don't think it matters that much whether an area is penetrated or saturated with statutes. I think it depends more substantively on how complicated and messy it is and whether it needs to be cleaned up. Also a lot of statutes now around insurance law, came from the common law, and a lot of statutes in other areas were once ALI restatements that were made into statutes. So the whole thing is, to me, just a bunch of different flavors of law creation. And the core thing is how much clarification do you need to bring to the arena of that particular topic?
Other questions? I can't see very well. I think perhaps we should give Dan the last word.
Oh, I don't have much of an ending in plan. So
supposed to dance now?
right. No, I guess I will just say thank you to all of you. In a lot of ways, this has been sort of the highlight of my career, so far at least. Maybe I'll win the Old Scholars Award. But it's but it's been really wonderful for me to see everyone here, to have these conversations, and I do hope that I hope that a lot of you have had the opportunity to meet other folks who you didn't know. But if you didn't, there's still time. We're going to end now, and I would, again, I guess, reiterate my call to find someone outside of your silo who works on stuff that you're interested in, because I think that we get, especially with, is insurance law itself a distinct topic? How do we conceptualize it? Is it contract law? Is it financial regulation? I think we do get too siloed. So I'm really appreciative that you're all here. I hope you enjoyed the conference. I know that the topics were varied, and that's one of the challenges in a conference like this is everyone's going to be more interested in some topics than in other topics, or have more familiarity with some. I may be the only person who was really interested in all 4 topics, by coincidence, I guess. But I'm very appreciative, and I'm really particularly appreciative to Ricky and Stephanie and everyone at ALI for helping put this together, and so thank you very much.